Trump's attorney stood at the podium with his hand raised, his mouth open, his expression holding the particular confidence of a man who had spent 23 years practicing law in federal courts across the country, who had made objections that worked, that held, that changed the trajectory of cases and careers and lives. His name was Robert Whitfield. He had gone to Harvard Law. He had clerked for 2 federal judges before starting his own practice. He had represented powerful people before, including, once, a senator who had been caught in a scandal that would have destroyed anyone else, but who had walked away clean because Whitfield had found the right angle and pressed it with the precision of a surgeon and the confidence of someone who had never lost a case he believed he could win. He believed he could win this case, too. He believed it because he had been hired by Donald Trump, which meant he had resources and visibility and access that most attorneys only dreamed about. He believed it because he had prepared for weeks, had reviewed every document, had anticipated every question the prosecution might ask, had built a defense that he understood down to its foundation because he had designed it himself. He had even rehearsed the objections with his team late into the night before the trial began, standing in his office in a suit he would not wear until the morning, saying the words out loud to an empty room and feeling how they landed and adjusting his tone until they landed exactly the way he wanted them to land. He did not know that in approximately 8 seconds the judge would say something that would make the gallery gasp and the objection crumble, and his face change, in a way that he would spend years trying to explain away in interviews and depositions and conversations with his own lawyers about what had gone wrong and why. He did not know that the room he was standing in was about to become the thing that people would talk about for a very long time, the thing that would be replayed on news programs and late-night shows and in compilations of the most dramatic courtroom moments of the decade. He did not know. He thought he knew. He was wrong. He was very wrong, and the wrongness of it was about to become the most important thing in his life for a very long time. This is a channel about those moments, the ones most people miss because they leave too early, the ones where something shifts in a room that you cannot see from the outside but you can feel when you are standing in it. We are going to spend some time in this room together, and I want you to notice what happens when the silence comes, when the pause stretches out longer than it should, when the person who walked in certain finds out they were wrong. That is where the story is. That is why you keep coming back. And what happens today in this room is exactly the kind of story that makes people stay, because the best stories are not the ones that shout. They are the ones that let the silence do the work and the truth arrive on its own schedule. They are the ones where the most important thing is not what is said, but what happens in the space between the words, the space where the room decides what it has just seen and what it means, and whether the person who caused it understood what they were doing or had no idea at all. To understand how the attorney's objection fell apart, we have to go back to the morning this all started. We have to go back to the weeks of preparation and the quiet confidence and the belief that everything had been handled the way it needed to be handled. We have to go back to the moment when Trump's legal team walked into the federal courthouse in Washington on the morning of March 15th and believed they were walking into a room where they would control what happened next. We have to go back to the lobby of the E. Barrett Pretterman United States Courthouse, where Whitfield had arrived at 8:23 that morning, 47 minutes before the proceedings were scheduled to begin, and had stood for a moment looking at the marble floors and the high ceilings and the portraits of judges who had served on that court before him, and thinking about the weight of the day ahead and whether he was ready for it. He was ready. He had been ready for weeks. He had gone over every document, every deposition, every piece of evidence that the prosecution might try to introduce. He had prepared his objections. He had prepared his cross-examinations. He had prepared his closing argument, though he would not need it for days. He had prepared for every contingency except the one that was about to walk through the door and sit down on the bench and watch him make the mistake that would change everything. The courtroom was on the 7th floor, room 322. It was a room designed for the theater of justice, with tall windows that let in the light and wooden panels that absorbed the sound, and a gallery that rose in tiers behind the bar desks. Designed to hold people who wanted to watch history happen. The seats were hard. The air was cold. The clock on the wall above the judge's bench read 9:47. In approximately 8 seconds, that clock would still be reading 9:47, and the room would be doing something that the room did not expect to do, which was gasp. But right now, in this moment, it was just a clock. It was just a room. It was just the ordinary machinery of justice beginning to turn, the way it turned every day in courtrooms across the country, carrying people into moments they would not forget. Barack Obama was there. He was not a party to the case. He was not a witness in the traditional sense. He was there because the case involved events that had occurred during his administration, events that had been investigated and reinvestigated and debated and politicized, until they had become the thing that people meant when they talked about the things that happened between 2017 and 2021, the thing that had led to 2 impeachments and countless investigations, and a national reckoning with questions about power and accountability that the country was still trying to answer. Obama had been called to provide context, to clarify timelines, to answer questions that only he could answer because he had been in the room when some of the key events had occurred, and had both the knowledge and the position to explain what had happened and why it mattered. He sat in the first row of the gallery, wearing a dark suit and a tie that was not too loud, with his hands folded and his face holding the particular calm of a man who had spent 8 years in rooms like this one, and had learned that the way you survive them is by never letting them see you sweat, never letting them see you flinch, never letting them see anything except the composed surface of a person who knows exactly where they are and what they are doing and why. Trump was there too. He was the one on trial. He sat at the defense table with his lawyers around him, wearing the particular expression of a man who believed that the trial was a performance and that he was the star of it. He had been in courtrooms before. He had won some and lost some, and learned from all of them that the key to surviving a trial was to make the room believe that you were the victim and not the defendant, that you were being persecuted by powerful forces who were threatened by your success and would do anything to bring you down. He was good at this. He had been doing it his entire adult life. He had learned it in the real estate offices of Manhattan, where a deal was never just a deal but a battle for position and dominance. He had learned it in the boardrooms where the word of the person with the most money was the word that mattered. He had learned it in the pages of the tabloids where his name appeared more often than almost any other name in the country. He had learned it everywhere he had ever been, and he had brought all of that learning with him into this room, into this case, into this moment, and he believed with the absolute certainty that had carried him through everything else, that it would work for him here too. The judge was a woman in her 64th year who had been appointed to the federal bench by Barack Obama. Her name was Patricia Chen. She had been a prosecutor before she was a judge, and she had tried dozens of cases, some of them big enough to make headlines, all of them important enough to matter to the people whose lives they touched. She had a reputation for being fair and direct and impatient with theater. She did not like performances in her courtroom. She liked facts. She liked order. She liked people who understood that the courtroom was not a stage for their ego, but a room where justice was supposed to happen, quietly and according to rules that had been established over centuries of human experience, with the simple idea that people who were accused of things deserved to be heard fairly, and people who brought accusations deserved to have their evidence tested rigorously, and the truth, whatever it was, deserved to come out into the light where everyone could see it. She had been watching Trump's attorney all morning, and she had been noticing things. She had been noticing the way he objected to questions that had not been asked yet. She had been noticing the way he interrupted witnesses mid-sentence with the particular timing of someone who had learned that interrupting was a form of control, a way of making the other person feel like they were walking on ice that could crack at any moment. She had been noticing the way he stood up fast, every time, with the confidence of someone who believed that getting to his feet was half the battle of making an objection work. She had been noticing the way he performed objection after objection like a man who believed that objections were his to use whenever he felt like using them, not as legal tools, but as power moves, as ways of controlling the tempo of the room, as ways of making the witnesses feel small and the jury feel uncertain, and the judge feel like she needed to accommodate his sense of importance. She had been waiting. She had been watching. She had been building a picture of what was happening and why it was happening and what it would take to make it stop happening. She did not take that kind of thing lightly. She understood that judges were supposed to be impartial, that they were supposed to give both sides a fair hearing, that they were supposed to resist the temptation to become participants in the drama unfolding before them. But she also understood that a judge's first duty was to the integrity of the proceedings, and that when one side was treating the courtroom like a stage for their own ego, the judge had an obligation to restore order, even if restoring order meant doing something dramatic, something that the room would not forget, something that would become the thing everyone remembered about the day the case was tried. She had decided in the quiet of her chambers before the session began that she would wait for the right moment. She would wait for the objection that was too much, the interruption that crossed the line, the performance that made it impossible for the proceedings to continue fairly. She would wait and she would watch and she would let the attorney build his own trap, and then she would spring it, in a way that the room would understand was not personal but professional, not a conflict between two people but a ruling on a point of law and conduct that the court was obligated to make. She did not have to wait long. The prosecutor was questioning Obama. The question was about a meeting that had occurred in the Oval Office during the transition period, a meeting where Trump had been told about something and had responded in a way that was now relevant to the case. Obama was answering carefully, precisely, with the particular care of a man who understood that every word he said was being recorded and would eventually become part of a record that would outlast all of them. A record that historians might one day read to understand what had happened in this room on this day. What had been said and why, and what it meant for the country that was still trying to figure out what it was, and who it was, and how the things that had happened in the years before this trial had changed the answers to those questions. The meeting occurred on January 7th, Obama said. I was present. The president-elect was present. Several other officials were present. The conversation was about the transition of power and the obligations that the incoming administration would inherit. There was a discussion about legal requirements that applied to classified materials. There was a discussion about the importance of following those requirements carefully. Trump's attorney stood up. He did not wait for the prosecutor to finish asking the question. He did not wait for the witness to finish answering. He simply stood, with the practiced speed of a man who had learned that getting to your feet fast was half the battle of making an objection work, half the battle of making the judge look at you and the jury look at you and everyone in the room understand that something important was about to happen. Objection, he said. Calls for hearsay. The witness is testifying about statements made by non-parties outside of the courtroom. The admissions of a third party cannot be used to establish facts relevant to the defendant's guilt or innocence. The prosecutor looked up. He was ready for this. He had prepared for this. He had known that the defense would object to this line of questioning and had reviewed the relevant rules of evidence and the exceptions that applied. He opened his mouth to respond, to explain why the question was not hearsay, to cite the relevant precedent and the specific reasons why the testimony was permissible. But the judge spoke first. Sit down, she said. 2 words. Whitfield's hand was still raised. His mouth was still open. His face was still holding the expression of a man who was about to win an argument he had been preparing to win all morning, who had been winning arguments like this one his entire career, who had learned the particular body language and vocal tone and strategic timing that made objections work, and who had deployed all of that learning in this moment with the confidence of someone who had never failed at this particular thing and could not imagine failing now. But the judge had spoken, and the words she had spoken were not the words he expected. The words he expected were overruled, or sustained, or at minimum approach sidebar. The usual words, the words that kept the game going, the words that let him win or lose in the normal way that attorneys win and lose objections every day in courtrooms across the country. Instead, she had said, sit down, which was not a legal ruling, which was an a decision on the merits of his objection, which was something else entirely, something that spoke directly to him as a person and told him that the performance he had been giving was over, at least for this moment, at least for this sentence, at least until he could figure out what to do next, and whether there was anything to do next at all. Objection, he said again, as if he had not heard her, as if the words, sit down, were not still hanging in the air between them like smoke that had nowhere to go, as if he could restart the moment and make it turn out differently than it was turning out. The witness is testifying about. I said sit down. The room went still. That was it, that was the moment, that was the thing that changed everything. Whitfield's hand was still in the air, his mouth was still open, but he was not speaking anymore. He was standing there in the middle of a federal courtroom, with every eye in the room on him, with the judge's words still echoing in the space between them, with the understanding that he had just been told to sit down and had not yet done it, and the not yet doing it was making everything worse, was making him look like someone who did not know when to stop, someone who was so accustomed to winning that he did not know how to lose. Someone who was about to learn something that he would rather not learn, but would have to learn anyway because the room was watching, and there was nothing he could do to make the room unsee what it was seeing. The silence that followed was 8 seconds long. This was the first silence. It came right at the 8-minute mark, right on schedule, the silence that builds the kind of audience that keeps watching videos like this one. It was the silence of a room that had just seen something it would not forget. It was the silence of an attorney who had just discovered that his preparation had not prepared him for this, that his experience had not taught him how to handle a judge who did not care about his experience, that his confidence had been a costume, and the costume had just been removed in front of everyone who was watching. It was the silence of a man who had built his career on the ability to stand up in rooms like this and make objections that worked, and now discovered that the ability was not enough, that the room was bigger than his ability, that the moment was bigger than the man who thought he could control it. The gallery was still, the jury was still, the prosecutor was still. Obama was still, his face holding the particular expression of a man who had been in rooms like this before and understood what was happening, and was not going to make the mistake of letting on that he had been affected by it, that he understood the significance of what had just happened, that he was going to continue doing exactly what he had been doing before the 8 seconds of silence began, and let the silence do its work without adding anything to it. Whitfield sat down. His face was doing something that faces do when they are trying to recover from a shock. It was trying to find its way back to neutral. It was trying to become the face of a professional who had simply been told to sit down, and was now sitting down as instructed, and was completely fine with it, and had not just been diminished in front of a room full of people who had been watching and would keep watching and would remember this moment long after the trial was over, and the verdict was in, and the case had become a footnote in some larger history of what had happened to the country in these years. It was not succeeding. The room could see that it was not succeeding. The cameras could see that it was not succeeding. The judge could see it, and she did not care, because what she had said was not about embarrassing him but about restoring order, and the order had been restored, and the room was moving forward again, and the silence was ending, and the next thing was about to happen. The judge looked at the prosecutor. "Continue," she said. She did not explain, she did not justify, she did not say anything else. She simply moved on, the way a judge moves on when they have made a point, and do not need to elaborate on it because the point has been made and everyone in the room knows it. Everyone has seen it. Everyone has absorbed it. And the only question now is what happens next. What the next question is. What the next answer is. How the story continues after the moment that changed it. Obama continued his testimony. He answered the question that had been pending, the question about the meeting in the Oval Office, the question about what had been said and who had said it, and what it had meant in the context of everything else that was happening during the transition. He answered it carefully, precisely, with the particular calm of a man who had seen this before, who had been in rooms like this before, who knew that the way you survive a moment like this is by not drawing a 10. On to it, by letting it happen, and then moving past it, and continuing to do exactly what you were doing before it happened. Because the thing that matters is not the moment itself, but what comes after it. What the room decides about you based on how you behave when the moment has passed, and the ordinary business of the day is resuming around you. This is what restraint looks like. This is what restraint looks like when it is working. It is not the dramatic moment. It is not the headline. It is the choice to keep going, to keep answering, to keep telling the truth in a room where someone else has just been shown the door. It is the choice to let the moment do its work without adding anything to it, without making it bigger than it needs to be, without turning it into a performance of your own. It is the understanding that the best moments in any story are rarely the ones where someone wins, but the ones where someone loses with dignity, where the room sees them absorb the blow and keep standing and keep speaking and keep being exactly who they were before the blow landed, which is the thing that makes the blow seem smaller than it actually was or larger than anyone expected, depending on how the person who received it decides to handle it. Obama understood this. He had been understanding it for decades. It was the thing that had carried him through rooms that would have broken less composed people, through moments that would have derailed less disciplined people, through the particular pressure of being the first black president of a country that had never had one and was not sure it wanted one, and was watching every move he made with the kind of attention that leaves no room for error. He had learned in those years that the most powerful thing he could do was nothing, was wait, was let the moment breathe and the room absorb and the truth settle into the place where it would do the most good. He had learned that from his grandmother, who had worked as a bank teller in Kansas and never raised her voice at anyone, and had taught him, without ever saying it directly, that the people who win are not the ones who shout the loudest, but the ones who stand the steadiest. The prosecutor continued. The questions kept coming. The room moved forward, the way rooms move forward after something has happened, carrying the thing that happened with them into the next moment and the next and the next, embedding it in the record, making it part of the permanent history of what occurred in that space on that day. And Whitfield, who had been told to sit down, did not stand up again for nearly an hour. When he did stand, it was to make a different objection, a smaller one, a quieter one, an objection that was designed to be less noticeable, less dramatic, less likely to provoke another response from a judge who had made it clear that she was not interested in performances. He had learned something. He did not know what exactly. He did not know if what he had learned would help him for the rest of the trial or if it had already damaged him in ways that could not be repaired. But he had learned something, and the learning was sitting in his chest like a stone, heavy and cold and impossible to ignore. At 11:23, there was a recess. The judge left the bench. The courtroom emptied in the particular way that courtrooms empty during recesses, which is slowly, with people gathering their materials and talking in low voices and checking phones, and looking like they need a break even though the break will only be 15 minutes, and will not be nearly enough time to process what has happened, to understand what it means, to figure out how to go back into the room and continue doing whatever it was they were doing before the room changed. Obama walked to the back of the room where a small group of people were waiting for him. He did not speak about what had just happened. He did not comment on the judge's ruling or the attorney's face or the silence that had followed the words, "Sit down." He simply walked and listened and prepared for what came next, because that was what he did. That was what he had always done. That was the habit of a lifetime. The habit of a man who understood that the next moment was always coming, and the best way to handle it was to be ready for it, to have thought about it already, to have decided what you would say and do and mean before the moment arrived, and you were caught without a plan. Trump stayed at the defense table. He was talking to his lawyers. The conversation was low and urgent, the kind of conversation that happens when something unexpected has happened, and the people involved are trying to figure out what it means and what to do about it. Trump was doing what Trump always did in situations like this, which was trying to control the story, trying to spin what had happened into something that worked for him, trying to find the angle that would make the sit down look like it was part of a larger narrative where he was the victim and everyone else was the villain, where the judge's words were evidence of bias, and the attorney's humiliation was proof that the system was rigged against him, and the only people who could be trusted were the people in his own camp who would tell him what he wanted to hear and help him believe what he needed to believe to keep going. It was not working. His lawyers could tell it was not working. They were nodding and not nodding at the same time, agreeing and not agreeing, the way lawyers do when they are trying to be supportive while also trying to figure out how to tell their client that the spin is not landing, that the room saw what happened, that the room is not going to forget what happened no matter how many times it gets reframed. Whitfield was one of those lawyers. He was the senior member of the defense team. He was the one who was supposed to know what to do when things went wrong. And right now, things had gone wrong in a way that he had not anticipated and did not know how to fix. He had been told to sit down in front of everyone, and he had sat down, and now he was trying to figure out how to recover from that, how to get back to the place where he had been before the judge spoke, how to make the room see him the way he needed to be seen, as a serious professional who deserved to be listened to, not as the man who had been told to sit down and had sat down like a child being scolded. When the recess ended, the room filled again. The judge returned to the bench. The proceedings resumed. The prosecutor continued questioning Obama, and Trump, still at the defense table, still surrounded by lawyers, was watching everything with the particular attention of a man who was trying to understand what had happened and why it had happened and what it would mean for the rest of the case. He had not expected this. He had expected the trial to go his way, to be a stage for his performance, to end with a verdict that vindicated everything he believed about himself and the world. Instead, he was sitting in a room where his attorney had been told to sit down and had sat down and was now trying to recover from something that could not be recovered from, at least not in the way he was trying to recover from it. The second silence came at the 16-minute mark, right on schedule. It was heavier than the first one. It was the silence of a room that was watching something happen that it had not expected to see. The prosecutor had just asked Obama about a document. The document was an email. The email had been sent by someone on Trump's transition team. The email contained language that was relevant to the case, language that established what the incoming administration had known and when they had known it and what they had done with that knowledge. Obama had reviewed the document before the hearing. He knew what it said. He knew it mattered. And he knew that the next few minutes would determine whether it ended up in the record or got excluded by an objection that the defense would have every right to make, that the rules of evidence were clear and the document was admissible, and the only question was whether the defense would object and whether the objection would succeed. The document shows, the prosecutor said, that the incoming administration was aware of the legal obligations that applied to the retention of classified materials. The email specifically states that the matter had been reviewed by counsel and that the counsel's recommendation had been rejected. This directly contradicts the defense's claim that there was no intent to retain the materials improperly. Whitfield stood up. This time he waited for the prosecutor to finish the question. This time he was careful. This time he was not going to make the mistake of objecting too soon, of objecting to something that had not been asked yet, of giving the judge another reason to tell him to sit down in front of everyone who was watching. He had learned that lesson. He was still learning it, still feeling the weight of the 8 seconds that had passed after the words, "sit down," had been spoken, still carrying the stone in his chest that had settled there when he realized that the room had seen him fail and would never forget that it had seen him fail. "Objection," he said. "Relevance. The email predates the alleged conduct by several weeks. It does not establish knowledge or intent regarding the specific materials at issue in this case." The prosecutor was ready. "Your Honor, the email establishes the state of mind of the parties involved. It shows that they were aware of the legal framework. It shows that they made a conscious decision to reject the advice of counsel. That is directly relevant to the question of whether any alleged retention was knowing and willful." The judge looked at the attorney. She looked at him for a moment that lasted longer than felt comfortable, the way judges look at attorneys. When they are deciding whether to sustain or overrule, the way judges look at attorneys when they want the attorney to understand that the decision is not automatic, that the judge is thinking, that the judge is not going to do what the attorney expects just because the attorney stood up and made a sound. The room was watching. Everyone was watching. The silence in the room had a texture to it. A hum, the sound of the ventilation system working against the weight of the moment, the faint buzz of the fluorescent lights overhead, the distant sound of a phone vibrating somewhere in the gallery where someone had forgotten to silence it. The room was holding its breath. "Overruled," she said. "The document is relevant. The jury may consider it." The attorney sat down. He did not argue. He did not push back. He did not do any of the things that he had been doing all morning, the interruptions, the theatrical objections, the power moves that were designed to make the witnesses feel like they were walking on ice. He simply sat down because he had learned something in the last hour, something that the 8-second silence had taught him, something that the words, "sit down," had embedded somewhere deep in his understanding of where he was and what was happening to him. He had learned that there was a judge in this room who was not impressed by him. And he had learned that learning that was not something he could undo, not something he could explain away, not something he could spin into a story about bias or persecution or the system being rigged against him. The learning was just there in his chest, next to the stone that had not moved. The prosecutor marked the document as an exhibit. The court reporter noted it in the record. The jury received it. The copies passed from hand to hand in the jury box, each juror looking at the words that had been written by someone who was now long gone from the administration, and had left behind only the email and the questions it raised, and the answers that were still being worked out in courtrooms and committees, and the larger court of public opinion where the case was being tried even before it had come to this room. Obama answered more questions. The room moved forward, the way rooms move forward after something has happened, carrying the thing that happened with them into the next moment and the next and the next, embedding it in the record, making it part of the permanent history. The third silence came at the 23-minute mark, right on schedule. This was the mirror moment. This was where the reflection was held up and the room saw what was really there. Whitfield had been quiet for the last hour. He had made small objections, technical objections, the kind of objections that attorneys make when they are doing their job but are not trying to take over the room. He had been subdued. He had been careful. He had been in the particular way that people are when they have been taught a lesson and are still absorbing the lesson and are not yet sure what the lesson means for the rest of the day. He had learned that the judge was not someone who could be pushed around. He had learned that his performance had been noticed and judged and found wanting. He had learned that the room was watching him with a different kind of attention now, not the attention of people who were waiting to see what he would do, but the attention of people who already knew what he would do because they had seen him do it, and had seen what had happened when he did it, and had made their judgments accordingly. But now he stood up again, and this time it was not to object to a question or to challenge a piece of evidence or to interrupt a witness mid-sentence. This time it was to make a statement. This time it was to try to take back the room that the 8-second silence had taken from him, to reassert his authority, to remind the room that he was still the senior attorney on the defense team and still deserved to be heard and still had things to say that mattered. "Your Honor," he said, and his voice was different, more formal, more careful. The voice of a man who had thought carefully about what he was about to say and believed that what he was about to say would change the dynamic, would reset the room, would make the judge understand that he was not someone who could be dismissed. "I would like to note for the record that the defense strenuously objects to the inclusion of this document on the grounds that it was obtained through improper channels and does not reflect the actual deliberations of the transition team. We maintain that any evidence derived from these materials should be excluded as fruit of the poisonous tree." The judge looked at him. She looked at him the way she had been looking at him all morning, the way she had been looking at him since he had stood up for the first time and made his first objection, and discovered that making objections was not the same as winning objections, that standing up was not the same as being right, that confidence was not the same as competence, and the room knew the difference even if he did not. The room was paying attention. The room had been paying attention all morning, and the room saw the judge lean forward and understood that something was about to happen. "Counselor," she said, and her voice had something in it that had not been there before, something that sounded like steel, something that sounded like the voice of a woman who had been in courtrooms for 30 years and had seen every trick and every maneuver and every attempt to control a room and had decided in this moment that she had had enough, that the patience she had been exercising had reached its limit, that the time for waiting had passed and the time for speaking had arrived. "You have made numerous objections today. Some of them were valid, some of them were not, but what I have observed is not simply a pattern of legal objections. What I have observed is a pattern of behavior designed to disrupt the proceedings, to intimidate witnesses, and to turn this courtroom into a stage for your client's political objectives. That is not what this courtroom is for. This courtroom is a place where justice is supposed to happen. And justice cannot happen when one side treats it as a performance." The room went silent. The silence was 21 seconds long. This was the third silence. It was the silence of a room that had just heard a judge say out loud what everyone in the room had been thinking all morning. It was the silence of an attorney who had just been told, in the most formal setting imaginable, that he had been performing and that the performance was over. It was the silence of a man who had walked into a federal courthouse, believing that he controlled what happened in the room, and was now discovering that the room had always belonged to someone else, that the control he had thought he had was an illusion, that the power he had been performing was a costume that could be removed at any moment by anyone who decided they had had enough of watching him wear it. Trump was watching from the defense table. His face had changed. It was not the confident face he had been wearing all morning. It was something else. It was the face of a man who was watching someone else take damage that he had expected to inflict and was now receiving instead. He had not expected this. He had expected his attorney to win every objection, to control every moment, to make the trial go the way he needed it to go. Instead, he was sitting in a room where his attorney was being diminished in front of everyone, where the judge was speaking about performance and theater, and the difference between justice and spectacle, where the silence that followed her words was the loudest thing in the room. Obama was watching from the gallery. He did not react. He did not show satisfaction or surprise or any of the things that a person might show when watching something dramatic happen. He simply watched, with the particular attention of a man who understood that the moment was significant and that the significance would become clear later, after the courtroom was empty and the transcript was filed and the story was being told by people who had been there. He had seen this before. He had been in rooms where someone was being shown the limits of their power and had recognized the look on the person's face, the look of someone who had believed they were in control and was now discovering that they were not, that the control had never been theirs to begin with, that the room had always been bigger than any single person standing in it. The attorney did not respond. He did not object. He did not argue. He simply stood there with his hands at his sides and let the silence do its work. He had nothing left. The objections had run out. The performances had been seen. The room had decided what it thought of him. And there was no technique left that could change that. No angle that could be pressed. No power move that could restore what had been lost in the 21 seconds of quiet that were still hanging in the air between him and the bench and everyone who was watching. "Continue," the judge said. The hearing moved forward. The questions kept coming. Obama kept answering. The documents kept being entered into evidence. The room kept moving, the way rooms move after something has happened. The way rooms absorb the thing and keep going because the thing has already happened, and there is no way to unhappen it, and the only choice is to keep going and let the thing sit in the record where it will live forever, where anyone who ever wants to know what happened in this room on this day can read the transcript and see exactly what was said, and when and by whom and how the room responded and what the response meant. At 1:47 in the afternoon, the judge called a recess that would last until the next morning. The jury W. As excused. The witnesses were excused. The attorneys were told to return at 9:00. The courtroom began to empty in the particular way that courtrooms empty at the end of a day, which is slowly, with people gathering their materials and talking in low voices and looking like they have been somewhere important and are now going somewhere else, somewhere ordinary, somewhere where the weight of what happened can settle into the background of a life that is continuing in all the usual ways. Trump stood up from the defense table. He gathered his materials. He looked at his attorneys. He did not speak to them. He did not need to. The look said everything. The look said, "This did not go the way I expected, and I do not know what to do about it, and we will figure it out tomorrow, and I am not happy, and you should have done better, and I do not know if you can do better, and what happens now depends on whether you have learned anything from what just happened in this room." His attorneys gathered their things. They walked toward the door. They did not look at the judge. They did not look at the prosecutor. They did not look at Obama, who was still in the gallery, who was still gathering his own materials, who was still moving with the unhurried calm of a man who had been through something significant and was now simply waiting to go home. Trump walked out of the courtroom. He did not speak to the cameras that were waiting in the hallway. He did not make a statement. He walked with the particular pace of a man who is trying to hold something together that is in danger of falling apart, the pace of someone who has just seen something happen that they did not expect to see and are still trying to understand what it means for them and for the case and for the larger story they have been telling about themselves and the world. He reached the elevator. He waited. The doors opened. He got in. The doors closed. The numbers on the display above the doors counted down as the elevator descended. 7654. And then the doors opened again, and Trump walked out into the lobby, and then out through the security checkpoint, and then out into the afternoon, where the sun was doing what the sun does, and the traffic was doing what the traffic does, and the world was continuing in exactly the way it had been continuing before he walked into the building, and before the 8-second silence, and before the words, "Sit down," had been spoken, and before everything that followed had followed. The courtroom was empty. The judge was in her chambers, reviewing notes, preparing for the next day, thinking about what had happened and what it meant, and whether the ruling she had made was the right one, and whether the words she had chosen were the right words, and whether the steel she had put in her voice was the right amount of steel or too much or not enough. She had been a judge for a long time. She knew that the words she used in the courtroom would outlive her, would be read by people she would never meet, in places she would never go, for reasons she could not predict. She had to be careful, but she also had to be honest, and what she had said was honest. What she had said was true, and the truth did not care whether it was comfortable or convenient or likely to be replayed on television screens across the country. The truth just was, and she had said it. Obama walked out of the courthouse at 1:52. The sun was out. The traffic was moving. The world was doing exactly what the world does, continuing in its ordinary way, while a man who had just witnessed something significant walked to his car and got in and thought about what he had seen, and what it would mean for the country that was still trying to figure out what it was, and who it was, and how the things that had happened in the years before this trial had changed the answers to those questions. He did not speak to the reporters who were waiting outside. He did not make a statement. He simply walked and got in the car and drove away, the way he had been doing for decades, the way he would keep doing until there was nothing left to do but stop. And the courtroom he had left behind was empty and quiet and still held the shape of what had happened there, the ghost of the 8-second silence, the echo of the words, "Sit down." the weight of the 21-second silence that had come after the mirror was held up, and the room saw exactly what was there, exactly what had been there all along. Exactly what the attorney had been trying to hide with his objections, and his interruptions, and his performances, and his belief that the room would believe whatever he wanted it to believe as long as he stood up fast enough and spoke loud enough, and never admitted that he was anything less than in complete control of everything that was happening. This story will keep working for the people who watched it the way it worked for the people in that room, the ones who stayed until the end, the ones who understood that. The best moments are not the ones that shout. They are the ones that sit quietly and wait for you to understand what has happened and what it means, and why it will matter long after the room has emptied, and the lights have been turned off and the only thing left is the truth, sitting on the bench, holding up the mirror, showing everyone what was there all along. Showing them that the performance was always just a performance, and the confidence was always just a costume, and the only thing that was real was the moment when someone decided to stop pretending and let the silence speak for itself. That is the story. That is the silence. That is the thing that stays with you after the room is empty and the transcript is sealed, and the cameras have moved on to the next thing, and the attorney who tried to control everything has gone somewhere to be alone with what happened and what it will mean for everything that comes next. The confidence was real, the performance was real, the objections were real, but so was the steel in the judge's voice, and the steel does not care about confidence. The steel only shows what is there. And what was there in that room on that day was a judge who had seen enough and a room that had watched, and a silence that said everything that needed to be said, everything that needed to be heard, everything that the attorney and his client and everyone in that gallery would carry with them for the rest of their lives as the thing that happened in that room on that day when the performance ended and the truth began. That is the end of the story, but it is not the end of what the story means. Because the story is not really about Trump's attorney or the judge or a federal courthouse on a particular afternoon. The story is about the moment when anyone at all, discovers that the performance they have been giving is not working anymore, and the room has decided to stop pretending that it is. The story is about the moment when confidence meets something that confidence cannot move, the moment when an objection lands and the judge says, "Sit down," and the room goes quiet and the mirror is held up and the room sees exactly what the mirror is showing. Exactly what has always been there underneath the costume and the confidence and the performance that seemed so real until the moment when it stopped being real, and everyone saw what was underneath and understood that underneath was all there had ever been. That moment happens to people every day, in courtrooms and classrooms and conference rooms and all the other rooms where people gather to do the business of being human. The moment is always the same. The moment is when you realize that the person you have been performing as is not the person you actually are, and the room has known it all along, and the only thing left is to decide what to do with that knowledge, whether to keep performing or to stop, whether to double down on the costume or to take it off, whether to stand up again and make another objection and hope that this time it works or to sit in the silence and let the truth be the thing that takes over. That is the question. That is always the question. And it is the question that this channel is built on, the question that brings you back, the question that keeps you watching, the question that matters long after the room is empty and the lights are off, and the only thing left is the moment when someone said, "Sit down," and the gallery went silent, and the attorney discovered that there are some rooms where performance does not work and silence is the only thing that does, silence and the truth that lives inside it, waiting, ready, patient, exactly what it has always been. Exactly what it will always be, the thing that stays when everything else is gone. That is why you stay. That is why we tell the stories. That is the thing that never gets old. The silence in that room was 8 seconds long the first time and 21 seconds long the second time. The silences are still happening. Somewhere in some room, in some moment that is happening right now, or will happen tomorrow, or will happen years from now, there is a silence that is exactly that long and exactly that heavy and exactly that full of the moment when a person discovers that the performance has ended, and the room has seen what was behind it, and there is nothing left to do but sit in the silence and let the truth be the thing that takes over, the thing that settles everything. The thing that stays long after the words have faded and the people have gone and the room is just a room again, waiting for the next story to come through its doors, and take up residence in its rows of seats, and its tiered platforms, and its air that smells like floor wax and recycled air, and the particular tension that happens when powerful people gather in a space that has been built to contain them. That is the thing. That is the only thing. That is the thing that stays.